Hi, everybody. Professor Schiefler, Stephan, and I are very proud and honored to introduce our two special guests for this final meeting of our course, Arbitration and Dispute Board with the Public Administration in Brazil, at the University of São Paulo Law School, Master and PhD in Public Law. First, we are delighted to introduce Professor Juan Pablo Valdivia Pisarro. Professor Juan Pablo is lecturer in arbitration and business law and at Erasmus School of Law, University of Rotterdam, Netherlands, and is also professional support lawyer at Linklaters in Amsterdam. We are very grateful for your presence here, Professor Juan Pablo, with us this morning. And we would like to thank you and thanks Professor Gerard Meyer for this opportunity to hear some of your specialized thoughts about the ICC dispute board rules for the next 15-20 minutes. Professor Juan Pablo.
Thank you very much. Thank you very much, Gustavo. Thank you, of course, to Felipe as well for the kind invitation. It is a pleasure to be with you. It is certainly an honor to be sharing this session with Professor Gustavo and also with Professor Stephan Schill, who will speak shortly after me. I remember the first time and the only time so far that I was in Sao Paulo was many years ago. And I arrived at the city and I found it particularly calm. It had been quite a long trip, and then I realized it was a Sunday afternoon, and then that was probably why I didn't see any traffic or traffic jams that I think are characteristic of the city. I am originally from Lima, Peru, so I'm also used to the traffic. But it is great to be with you and to share this moment, to have a nice conversation about this. And to visit Sao Paulo, albeit virtually today. I believe perhaps, I don't know if Felipe is already with us, that he may be able to share some slides.
I will help you out here. I will help you out. So I'm going to start the presentation, okay?
Okay, perfect. Thank you. Thank you, Gustavo. So, well, the slides come up on screen. Hello, everyone. It is great to be here. Today, I will briefly talk about the ICC dispute board rules for what I briefly managed to see in the presentation of one of your classmates that just finished. I saw that you're of course familiar with dispute boards, the main proceedings, the type of boards. So I may skip or just go slightly fast through some of the slides or the content. But in doing so, in discussing the ICC rules, one of the things that I want to do is to discuss also some of the interesting issues or aspects regarding dispute boards and the decisions that dispute boards render. This, of course, because of the limited time that we have, will be only a limited overview and an introduction to the rules. As you know, I saw it already done, and the ICC dispute board rules are just one of the several sets of rules that are available to parties to a mid-term or long-term project. Other organizations that have similar sets of rules, of dispute board rules, of course, are, as you know, the Chartered Institute of Arbitrators, for example, they were published in 2014, FIDIC, as you already saw, and the American Arbitration Association. Now, today we will focus on the rules published by the ICC, also because, of course, the familiarity that we all have with the ICC as an international organization, one of the main arbitration institutes in the world, and because we are also familiar with the ICC arbitration rules, which may allow us and help us to draw some interesting comparisons if the time allows us to do so, or otherwise during the questions. Now, in the next few minutes, I would like to discuss the following topics. First, I will provide a brief, general overview about the rules themselves and their scope. Then I will discuss the three, or mention briefly, I know you know them well, the three types of dispute boards that are envisaged by the ICC rules. If we have some time, perhaps I would like to mention a few highlights in relation to the establishment, the operation, the powers, the procedure, and the conclusion that dispute boards under the ICC rules can issue. And finally, and I think this is an interesting, or perhaps the most interesting topic that we will discuss, I would like to touch upon an interesting and controversial, semi-controversial perhaps, topic, which is the enforcement and enforceability of dispute boards, not only in relation to the decisions or conclusions, but also in relation to the procedure. Now, I believe we do not have the slides yet on the screen, or this is not a problem if we do not have the slides, Gustavo. I will continue. Yeah, I see, and apologies, I just see a file, a Windows Explorer window. So perhaps it's maybe sharing the PowerPoint instead of the specific window. But in the meantime, I will continue. This will be the introduction, so we will be absolutely fine. So of course we know that dispute boards are not a new phenomenon. We can date them back to the 1960s. The origin is widely considered to be in the United States through dispute review boards mainly. And of course, as dispute boards became more widespread, institutions published rules and guidelines to assist in the dispute resolution procedures managed by dispute boards. The ICC specifically first adopted the rules in 2004. Yeah, perfect. This is the right slide. Thank you. And the 2004 rules were revised into the current version that came into effect in October 2015. Now, the revised rules are largely the same as the original one, but there are a few interesting amendments. The revisions mainly focused on enhancing the effectiveness of the rules and clarifying the powers of the dispute board. Now, for example, the 2015 revisions empower the dispute boards to actively assist in the avoidance of disagreements and not only to serve as mediators or adjudicators, but also empowered the dispute boards to decide, for example, on interim measures, something that was lacking in the 2004 version, and to decide on the appointment of experts, although with the agreement of the parties. And perhaps most importantly, the revisions enhance the effectiveness of the decisions that dispute boards can render by expressly indicating that the conclusions would become not only binding, but also final upon the parties, and that the failure to comply with the decision of the dispute board would entitle a party to go straight to arbitration if that was the chosen method for resolution of disputes, without having to go to the dispute board first. Importantly as well, the rules clarified that a party cannot raise any issues in relation to the merits of the dispute board decision itself in order to justify any potential lack of compliance with the decision or the recommendation. Now, of course, we all know what the dispute boards are exactly. They are rules that provide a framework for the constitution and operation of a dispute board. And the proper and smooth operation of these bodies is especially important because, of course, dispute boards are used primarily in large construction or infrastructure projects, although not exclusively in them. And one of the main aims of a dispute board is not only to settle disputes, but also to help the parties avoid them. So are dispute boards actually useful? Well, according to the data that was made available by the Dispute Resolution Board Foundation, or the RBF, which is a non-for-profit organization based in the United States, since the 1980s, dispute boards have been used in about 2,800 disputes. And in over 85% of these cases, the recommendations or decisions that were issued by dispute boards were actually not followed by litigation or arbitration, which means that they were either complied with by the parties or helped the parties settle the dispute or disagreement. Now, from the data that was analyzed also by the DRPF, one can see, or this data suggests, that the presence of a dispute board alone helped to discourage disputes as well. Now, the ICC dispute board rules, of course, then is a framework in which these procedures take place. And if we open up the rules, we'll see that the rules deal with issues such as the appointment of members of the dispute board, the functions, the remuneration of its members. Importantly and relevantly, the ICC dispute board rules focus on standing bodies, not on ad hoc dispute boards, which means, of course, that bodies that are from the beginning until the end of the project. And an important consequence of this is that the dispute board will be familiar with the contract, with the progress of the project, and the performance of the parties. If we could go to the next slide, please. Now, how do the ICC dispute board rules become applicable? As you suspect already, by agreement of the parties. Dispute boards are a creature of contract and a creature of consent. In that sense, it is very similar to how arbitration agreements or arbitration clauses are incorporated into a contract. Parties will often include an ICC dispute board clause into the medium or long-term project contract. And just like in arbitration, the ICC also provides a number of standard clauses that parties can adjust and tweak as they deem fit. If you see the rules, there are three types of standard clauses in the rules that correspond also with the three types of dispute boards that are available under the ICC rules. Now, something that is interesting, and that this is different from arbitration and from the ICC arbitration rules, is of course that parties can decide to apply the ICC dispute board rules without relying on the ICC. This is because the ICC does not administer dispute board proceedings. The ICC will provide a number of administrative services to facilitate the application of the rules, but they do not administer the proceedings as they would do, or as the ICC Court of Arbitration does in relation to disputes that are being resolved by tribunals under the ICC arbitration rules. Now, of course, when it comes to dispute boards specifically, some of the services that the ICC provides through the competent body, which is the ICC International Center for ADR in this case, which is totally separate from the ICC Court of Arbitration. Some of the services are appointing dispute board members, for example, deciding on challenges to the members, and reviewing decisions when the parties agree for the ICC to do so. Now, what does a dispute board do exactly under the ICC rules? And this, so will be very, very succinct. Mainly, it provides three services. The avoidance of disagreements, to play an active role in the avoidance of disagreements. And this is one of the additions in the 2015 revision. The second one is to informally assist the parties to resolve a disagreement. And in this capacity, the dispute board acts as a sort of mediator, so to speak. And finally, to issue a termination, which is called a conclusion in the ICC rules. If a party formally refers a disagreement to the dispute board, and only when the party refers a disagreement to the dispute board under the ICC rules, this disagreement becomes a dispute, and at that moment, the process becomes more adjudicative, which is something we are more familiar with, of course, also through arbitration. If we could go to the next slide, please. Now, the three types of dispute boards that are envisaged under the rules, you are familiar with, I am sure. The different type of boards are mainly distinguished by the type and the nature of the conclusions that they can issue. These conclusions can be either a decision or a recommendation, and the essential difference between them is that the parties are required to comply with a decision without delay as soon as the decision is rendered. A recommendation only becomes binding if no party objects to it within the certain time frame as provided for in the rules. Now, the first type of dispute board under the ICC rules is a dispute review board. You are familiar with it. This review board will issue recommendations, which will only become final and binding after 30 days. And of course, if within the 30 days, one of the parties files a notice of dissatisfaction, which is the objection, then the entire dispute may be submitted to arbitration, will be seen, of course, from scratch. And in the meantime, the parties are not required to comply with the recommendation. The dispute adjudication board is the second type, and this is the board that will issue decisions that must be complied with immediately. Again, parties can file notice of dissatisfaction to submit the dispute to arbitration, of course, but in the meantime, they remain contractually obliged to comply with a decision. And the third type, which is an interesting one for the ICC, because it's a hybrid type that was put together and inserted in the ICC rules already back in 2004, is a combined dispute board, which offers an intermediate step between a dispute review board and a dispute adjudication board. By default, the CDB, the combined dispute board, will issue recommendations, but may also issue decisions basically in two situations, which is if a party requests so and no other party objects, and if the dispute board itself considers that it is necessary. For example, in a situation in which a decision is urgent and a binding decision would be the best way to facilitate the performance of the contract and to avoid losses. Now, at this point, I had originally thought to talk about a bit the establishment, the operation, the powers, and the procedure of the dispute board, because there are some interesting parallels that can be drawn with the ICC arbitration rules, many of them, and there are, of course, several very interesting differences between them. These differences obviously correspond to the different nature that a dispute board procedure has when compared to a formal arbitration and let's say a full-blown arbitration procedure. But since we do not have too much time today, then I thought perhaps we can just turn the heat up a notch, only a bit, and discuss a nice controversial or perhaps a bit more interesting issue, which is the enforcement and the enforceability of dispute boards, procedures, and decisions. If we could go to the next slide, please, Gustavo. Perfect. Now, here I will talk about the enforcement of the conclusions of a dispute board in ICC proceedings, but also about the enforceability of the dispute board procedure itself. And to do this, I propose that we draw a comparison with international arbitration, which is a framework with which we are also comfortable, which we know well as well. Now, if we think of international arbitration, of course, the issue is familiar in a way. If we think about the enforceability of arbitration agreements, we know well the separability doctrine, that the arbitration agreement is separate from the contract. If the main contract is invalid, this does not necessarily affect the validity of the arbitration agreement. The arbitration agreement itself may be subject to a different law than the law that governs the underlying or the main contract. This principle of separability is recognized basically in all jurisdictions. It's key to ensure the effectiveness and the workability of arbitration as a dispute resolution method. If we think about enforcement in international arbitration, of course, the New York Convention will come to mind. The New York Convention also deals with the enforceability of arbitration agreements, of course. But we think of the New York Convention, one of the most successful instruments in international trade law. 166 states are parties to it. We will also think of the UNCITRAL model law. The last two articles thereof will deal with this issue. Now, let's move now to dispute boards and how the procedures and the arbitration and the decisions, can be enforced. Now, we know that dispute boards are based on contract. They are enforceable as a contractual obligation. There is generally no regulatory framework for dispute boards or for this type of adjudication as there is for arbitration. with the exception of a few jurisdictions like the UK, where there are certain legal frameworks for the adjudication of disputes in the construction industry. But in general, there is no such a similar regulatory framework as the one that you have for arbitration in the form of, for example, national arbitration acts. Now, the dispute board clauses are in principle not separate from the main contract into which they have been incorporated, unlike arbitration agreements. And so in principle, the applicable law to the dispute board clause and to the dispute board procedure will be the same as the governing law to the contract. However, this is not always the case. There have been cases in which the applicable law to the arbitration agreement was actually found to be the applicable law to the dispute board clause and the procedure. One of the cases, or perhaps the most famous case, took place in Switzerland. I will not go into detail, so we can cover the second part of the enforcement issue. But we can say that in general, the dispute board clause is not separable from the main contract as arbitration agreements usually are. So if we think of dispute board procedures, we can say the following. They are in principle a mandatory precondition to formal proceedings, which means that you need to go through them before you can resort to arbitration. This is mostly recognized and enforced in all jurisdictions. Then the question may arise, and then you may think, but then is it possible to bypass a dispute board in certain circumstances? The answer is yes, but this will only be possible in a very specific set of circumstances, and will also depend on the jurisdiction. And a case that is useful to illustrate this is Switzerland. For example, there, in that case, the Supreme Court of Switzerland said that a claimant could actually bypass the dispute board based on the civil law principle of good faith. Although the Supreme Court did recognize that the dispute boards were a mandatory precondition to arbitration. In that case, what happened was a dispute board was not constituted, at least in part, because of the lack of cooperation of the respondent. And the Supreme Court in that case said that the claimant was justified in bypassing the dispute board, and that the respondent could not, in good faith, anymore, and at that point require the dispute board procedure to be followed when it had prevented, in apparent bad faith, the constitution of the dispute board itself for over a year. Now, in civil law jurisdictions where the principle of good faith is well established, there is a significant number of arbitral awards that allow the concept of good faith to be used to bypass the dispute board when the dispute board process has been disrupted by tactical maneuvers by one of the parties. But in general, the rule is that a party cannot go straight into arbitration, circumventing the dispute board procedure without a valid justification. How do we know, of course, if the justification is valid or not? In the case of arbitration, if arbitration is the formal proceeding to settle the dispute through the well-established, well-known principle of competence. It will be the arbitral tribunal itself that will determine if the justification is valid or not. So in that sense, provisions in a contract mandating DB or dispute board procedures are certainly enforceable. Now,
I think that we had some problem with Professor Juan Pablo. He's out of our meeting, but I think that he's going to come back. Just let's wait for a few moments, please. Something happened with his connection. Probably. So.
Can you hear me?
Yeah. now we can hear. Yeah. Please go on, Juan Pablo. Go on, please. Thank you.
Yeah, I think I know where I stopped. Apologies. I think something went wrong with my connection. So now let's move briefly to the enforcement of the decision of a dispute board, and I will be brief, so because I certainly do not want to step into the time of Professor Schill. Now, in principle, the answer in relation to the enforcement of the decision of a dispute board is straightforward. Let's first imagine the decision or recommendation that is binding and, most importantly, has also become final. This means that a party did not object the decision, of course, within the 30 days that are provided in the ICC rules. That means that they accepted the decision or recommendation and now has become not only binding, but final as well. Now, the conclusions that are issued by a dispute board are not enforceable at law as such. And unlike arbitral tribunals, there is no such a thing as a New York Convention type of instrument for dispute board decision. So a dispute board decision or conclusion is not an enforceable title by itself. However, the conclusions of a dispute board are enforceable in the sense that they are contractually binding on the parties in the manner that the parties agreed upon and in the manner that is described by the applicable rules. So in the case of the ICC rules, for example, we know that especially after the revision of 2015, dispute board decisions can become not only binding, but also final. Once a conclusion has become final, the parties are not allowed, based on their own contractual arrangement, to relitigate the same issue before an arbitral tribunal or a court. So can a dispute board decision be enforced? Well, if a party does not comply with the conclusion of the dispute board, of course, the other party can then attempt to give effect to that decision by seeking to enforce it through arbitration. So it's not directly enforceable, but arbitration, if that is, we are assuming that arbitration is a selected forum, can be used as a way of enforcing the decision. And importantly, the ICC rules indicate that when such non-compliance takes place, the party can go straight to arbitration to claim that the failure to comply with it is indeed, of course, a breach of the contract between the parties. So the issue may be quite straightforward in a way, and it may not take too long for the tribunal to arrive at its determination. A party was contractually obliged to comply with a decision, but it did not. And it is now also contractually obliged not to relitigate the decision because it was final, and the parties should certainly not be able to do that, and the tribunal should not allow so. Now, the claimant, of course, could resort, if available, to expedited or fast-track arbitration to ensure that the contractual rights are secured. If necessary, a party could certainly request the arbitral tribunal to order interim measures to safeguard the efficacy of the decision of the dispute board. Emergency arbitration, if available, could also be a very effective means. And as an alternative, of course, interim measures or seeking interim measures before national courts as appropriate. Now, and finally, the issue that may be a bit more problematic is the enforceability of decisions that are binding but have not become final. That means that a party indeed objected to that decision or recommendation. In that case, of course, when such objection is filed, that means that the dispute can be relitigated from scratch before an arbitral tribunal. And whether such decision can be enforced through arbitration is actually questionable. And this will vary from one jurisdiction to another. And the enforceability of such binding but not final decision will depend on several factors, perhaps most relevantly, the wording of the contract itself, for sure, because the dispute boards are a creature of contract. So the language of the contract and the rules on the possible enforceability of such decisions will be key. And another consideration that is important is whether an arbitral award that would enforce a non-final decision would actually comply with the requirements of an enforceable arbitral award under the legislation of the place where enforcement would be sought. Now, there are some jurisdictions in which a non-final dispute board decision may be enforced via arbitration. I believe Singapore is one of them, but no generalizations can be made in this regard. My personal opinion is that in principle, the enforcement of such decisions should not be problematic. They are interim and temporary in nature, that's true. And a final decision on the merits may be pending, but that does not mean that by definition, binding and non-final dispute board decisions should not or cannot be enforced. A parallel can be drawn, for example, with the enforcement of interim measures in arbitration. It can be done. It is not universally accepted. It is somewhat controversial, perhaps, but there are several jurisdictions in which they can be enforced, and the enforcement of interim measures is a fundamental step in order to secure the final effectiveness of an arbitral award. Of course, and just to finish very quickly, dispute boards are a useful tool. They are a standing body. There are costs involved with it, but just to put it in perspective, I thought this is an interesting data or a piece of information. The average cost of a standing dispute board from the beginning until the end of the project is about 0.15% of the total value of the project. This means, for example, for a project that is valued at $100 million, the cost of the dispute board would be about $150,000. The cost of arbitration are much, much higher than that. Only the filing of one submission in a complex arbitration proceeding could be double of that amount. So dispute boards are certainly an interesting mechanism, and the enforceability of the decisions of the procedures are, albeit controversial, I think an interesting topic to discuss. And with this, I would like to finish and, of course, give the floor to Professor Schill, and back to you, Gustavo.
Okay, thank you very much, Juan Pablo, for your participation here with us this morning in Brazil and afternoon in Holland. Juan Pablo, please, would you stay with us a little longer, or you have to leave right now? Okay.
No.
All right. We do have some questions for you, but we would like to go directly to Professor Stephan Schill. Is this okay? We can pose the questions after the presentation of Stephan Schill. Is it okay, Juan Pablo?
Absolutely.
Okay, thank you so much. So now, we are thrilled to introduce Professor Stephan Schill, who is Professor of International and Economic Law and Governance at the Faculty of Law of the University of Amsterdam-UvA. He is also editor-in-chief of the Journal of World Investment and Trade, one of the major journals in international economic law. I met Professor Schill while living in Germany, in Heidelberg, 2013. And since then, we try to keep in touch and collaborate. For the next 15-20 minutes, Professor Schill is going to share with us some thoughts about the constitutionality of private-public arbitration in Germany nowadays, currently pending before the Constitutional Court in respect of CETA, the Comprehensive and Economic Trade Agreement, which is a trade deal between the European Union and Canada. Professor Schill, please.
Yeah, Gustavo, thanks a lot for the introduction. Good morning to everybody in Brazil. Good afternoon to everybody in Europe. I assume that it's nice and sunny and warm out where you currently are. We've had our first snow last night, so getting here this morning on bike was a bit difficult. I sent a PowerPoint presentation beforehand. If somebody could get that started, it would be much appreciated, as I'm not entirely sure whether I manage Google Meet. It's the first time I'm on it. we use Zoom regularly, and that's the one that I'm really familiar with.
No, that's the wrong one. No, it's not this one. Just a minute.
The one below, yeah.
Mm-hmm. Okay. Do you see it?
What I see is still the Explorer with different files open.
Just a minute, please. Okay.
No problem.
Is it okay now?
No, it's still the Explorer I'm seeing.
Oh, sorry.
But
just
actually, I think I found the button how I can actually share my screen with you.
would you like to give a try? I don't know what's happening here. Yeah.
Do you see it on screen now?
No, not yet. Sorry about that.
I can see it on the screen. I can see the slide on the screen. I don't know if it's the same for the rest.
So you have a slide on the screen that says the constitutionality of ICS.
We see it right now. Thank you, Stephan.
Okay, perfect. So what I thought of doing in the 15 or 20 minutes that I have is to discuss with you or introduce to you the idea of the impact that constitutional law can have on international arbitration. I'm going to focus specifically on investment treaty arbitration, so on arbitrations under international investment treaties. Now, that is something that Brazil does not know in this form. Brazil is one of the few countries worldwide that has not concluded international investment agreements that include investor-state dispute settlement provisions, but there are Brazilian companies that make use through subsidiaries incorporated elsewhere and then have investments in foreign countries of these mechanisms only under investment treaties that, let's say, the Netherlands, for instance, have concluded with Bolivia or other countries. So investment treaty arbitration is what I am going to focus on, and I'm going to focus on the German debate that we have on the impact of constitutional law on investment treaty arbitration. Now, German law here is really just one example of how constitutional norms increasingly impact how we think about international arbitration, how we conceptualize it, and also what kind of limits there may be for states to engage in international arbitration. One has similar debates and similar court cases going on, for instance, in Colombia, in France, in Bulgaria, in Latvia, and also in regional courts. So the Court of Justice of the European Union, for instance, has asked the question whether certain investor-state dispute settlement mechanisms were constitutional. Now, in Germany, this is a debate which is relatively new. So until roughly 2012, there has hardly been any debate about the intersection between constitutional law and international arbitration. And this changed principally because competence for foreign investment issues was transferred to the EU, and the EU then started negotiating treaties that included investor-state dispute settlement provisions inter alia with Canada. So this is the famous CETA that Gustavo already mentioned, but also with the United States under the so-called Transatlantic Trade and Investment Partnership. These type of provisions ultimately led to a still pending proceeding before the Constitutional Court, where various opposition parties, but also individuals under individual complaint procedures claim that investor-state dispute settlement provisions included in CETA are contrary to the German constitution. So this is the background of the following substantive discussions. And I think, as will become clear during those discussions, it's important that one distinguishes two aspects. One is investor-state dispute settlement or investment treaty arbitration as a form of settling an individual dispute, and distinguish that from investment treaty arbitration as a mechanism of governance. And what that will mean, I hope, will become clear through my presentation. This is the outline that I want to address. So first, contextualize the debate a little bit, then address the perspective, is there any reason, any positive reason from a constitutional law perspective, why investor-state dispute settlement may be a constitutional demand, may be a constitutionally justifiable thing. Then I will turn to the constitutional critique, which is the main focus, also the focus of the pending CETA challenge, and finally provide an outlook. Now, Germany is a country that has concluded more than 140 investment treaties. It has been the first country to conclude an investment treaty, starting with the bilateral treaty in 1959, concluded with Pakistan, and since then has had a very active investment treaty practice that started including investor-state dispute settlement provisions in the 1980s. No constitutional debate has existed for a long time, probably because the principal interest actors had in these treaties was to protect German investments abroad. This changed principally in the early 2000s, when the first claims were brought against Germany under these type of investment treaties, specifically the Energy Charter Treaty. And we've had two claims in particular being brought by the Swedish power producer Vattenfall against Germany. One that concerned principally administrative law dispute about certain environmental conditions for a coal-fired power plant in Hamburg. This is a dispute that settled relatively quickly. The second one is a still pending dispute concerning an issue of constitutional law, namely to which extent Germany's nuclear power phase out that was decided a couple of years ago after the Fukushima disaster constituted a violation of Vattenfall's rights under the Energy Charter Treaty. So this dispute really brought the existence of investor-state dispute settlement mechanisms to the attention of the German public, probably to the attention of a European public, and very quickly led to critique, not only at a purely political level in parliament, but you really had people going on the streets protesting against investor-state dispute settlement mechanisms. And here you see a picture of one of those protests in front of the Brandenburg Gate. Reportedly, 150,000 people attended those protests. So pictures that really recall similar pictures when the German wall came down in 1989. Here, the same amounts of crowds in front of the Brandenburg Gate. So this, I think, indicates the political importance that this topic has really gained. Now, how did we get there? And how come sort of a very active investment treaty practice and a practice of including investor-state dispute settlement in these investment treaties has gone unnoticed for so long and then completely turned around into heavy political critique? For a long time, from a constitutional law perspective, the focus, of course, was not on what kind of rights and dispute settlement mechanisms did these investment treaties grant to foreign investors in Germany, the principal perspective was one of German foreign economic policy. And the question was really prevalent: what kind of protections can the German government grant to German investors abroad, particularly in countries where the rule of law may not be at the same level as in Germany, and where domestic courts were either not functioning as independently and impartially as they should, or where foreign investors lacked the trust in the neutrality, independence, and impartiality of domestic courts abroad. So this was the principal perspective. And the idea was then to grant substantive rights that mirrored rights that you also find enshrined in the German constitution. So protection under the rule of law, property protection, enforcement of contracts, and to give German investors abroad a right to access an independent, neutral, and impartial dispute settlement mechanism, which, for lack of any other alternative, was arbitration under these treaties. And only because the German government was demanding these type of substantive and procedural rules from its contracting state party abroad, it also had to confer the same type of rights on the basis of reciprocity to investors from that foreign state in Germany. And that was also a sensible thing to do from a constitutional law perspective, from the perspective of German constitutional law, because German constitutional law knows a number of limitations when it comes to the protection of foreign investors in Germany. The most important one here are listed: a number of fundamental rights that are important for economic activities, such as the right to enterprise, is a right that the German constitution only grants to German nationals, not to foreign nationals. So an investment treaty would grant those same type of rights to the foreigner in Germany. The German constitution, on the other hand, and that is similar to constitutions elsewhere, also grants relatively large possibilities for differentiated treatments between nationals and foreigners. So it allows for discrimination of foreigners. And this is, of course, also an area where an investment treaty then jumps in and closes a gap in protection. And the final limit that foreign investors faced was particularly with respect to foreign corporations, limitations in their access to the Constitutional Court. The Constitutional Court is only open to domestic corporations, and by now also corporations from other EU member states, but it is not open to corporations from outside the EU. So all of these gaps, both in the protection of foreigners abroad, limitations under the domestic law of the whole state, and limitations under German constitutional law for the protection of foreign investors in Germany, made it really, from a constitutional perspective, justifiable to conclude these investment treaties because they closed certain constitutional gaps. Now, this is the positive take on investment treaties and investor-state arbitration. The principal constitutional law debate and perspective that we're having these days is the contrary perspective. So one that focuses on the protection of foreign investors in Germany, and where the man and the woman on the street in front of the Brandenburg Gate just say, how come foreign companies have special protections? This sentiment resounds with the left, particularly in Germany, with the far right as well, and it's a mixture of anti-capitalist movements or anti-capitalist sentiments, anti-American sentiments, and anti-big company sentiments. And what this critique also focuses on is not only on investor-state dispute settlement mechanisms deciding an individual dispute, but also on arbitration tribunals actually acting as lawmakers in this field, acting as instruments of governance. And what I mean by that can be illustrated by looking at a standard clause you find in many investment treaties, a clause on fair and equitable treatment. And if you ask anybody about 20 or 30 years ago what exactly this clause meant, the answers were probably relatively hesitant, and people said, well, I don't really know, there's not much practice on it. Now today, what's very much established is that arbitral tribunals have really forged and concretized and further developed the content of such obligations through systems of precedent. And here the Waste Management Tribunal is an early and very clear instantiation of what this means. So tribunals actually drawing on earlier tribunal decisions in order to concretize what certain standards of treatment mean, standards that public authorities, so the state itself, has to abide by in order to live up to its commitments. So in this fact, so the fact that arbitration tribunals, ad hoc bodies, start developing certain areas of law, of public law, leads to, I think, problems from a constitutional law perspective, because the typical constitutional law perspective is of a legal order that is pyramidical, that is ordered, that is structured, where the constitutional court can influence what dispute settlement bodies under its authority do, what its limits are. And this shifts completely if you think about international arbitration. I always try to, or like to, analogize international arbitration with a Jackson Pollock painting. So it looks very disorderly. And the question then would be, from a constitutional law perspective, how can one actually see order here? And how can one ensure that the public interest is not undermined through the activity of these many ad hoc arbitral tribunals that are not under this hierarchical control? There are a number of specific constitutional law problems that investment arbitration raises. If you think about this of being a system of privatization of justice, it's a system limited to foreigners. You find a number of inconsistent decisions. You have a procedure that deals with private-public disputes that often involve the public interest, but where the procedure itself is geared and is based essentially on commercial arbitration, private arbitration rationales with equality of parties, burdens of proofs, taking of evidence, and so on and so forth, modeled essentially on the basis of a commercial arbitration model. You have, on the other hand, arbitrators developing the law, concretizing it, and that then raises the question, what exactly is the legitimation of those arbitrators, and what are control mechanisms that ensure that whatever they do, however they decide disputes, they do in a way that public interests are not undermined. And these tensions then lead to a number of very concrete alleged violations of the German constitution or of other constitutions before other constitutional courts. And I think these are the four categories of norms that one sees generally invoked in these type of proceedings. So norms relating to state organization, and that is particularly the way that the Constitution provides how the judicial system and the separation of powers between courts, the executive and the legislator is supposed to look like. The issue of equal treatment, the concept of the rule of law, and the the principle of democracy. If you look at the text of the German constitution, then norms relating to state organization are principally the three that you see up on the screen. The first one, Article 19, paragraph 4, is a right to have access to justice against acts the public authority takes in relation to individuals. So access to justice against public authority. Article 92, vesting of judicial power in the judges. And finally, Article 101, the prohibition of extraordinary courts and the right of individuals not to be removed from the jurisdiction of the lawful judge. And all of these provisions, some argue, are violated through public-private arbitration because cases are withdrawn from domestic courts and moved into arbitration. I don't think that this is really a constitutional issue, because both the public and the private party agree to arbitration, and arguably these provisions protect an individual's right to have access to domestic courts, a right that can be waived, but nonetheless these norms are claimed to be violated in the current pending constitutional law challenge. The other key norm is Article 20 of the German Constitution, and that norm contains the right to democracy, the principle of democracy, in stating that all state authority is derived from the people, which shall be exercised by the people through elections and other votes, and through specific legislative, executive, and judicial bodies. And the third paragraph is the norm that contains the principle of the rule of law, where it says that the legislator, so the legislative branch, shall be bound by the constitutional order, the executive and the judiciary by law and justice. So in these norms, it is claimed, are violated because inconsistent decisions pose a problem for the rule of law. The question whether arbitrators are controlled and legitimated and are truly independent and impartial may create a problem for the rule of law. The alleged lack of predictability of some of the decisions that arbitral tribunals are rendering is also an issue that is claimed to be a breach of constitutional law. And on the other hand, you have a variety of arguments that really zoom in on the democratic principle. And claims that are brought here is that investment treaties and investor-state dispute settlement does not leave sufficient space for democratic self-determination, that processes of public democratic deliberation are undermined by these treaties and dispute settlement mechanisms, that disputes aren't sufficiently transparent, that third parties that are affected cannot participate in those proceedings, and finally, that arbitrators are not legitimized in a way demanded by the principle of democracy, because it is, in the end, parties to a proceeding appointing arbitrators rather than judges with a permanent tenure being appointed through democratic processes that somehow take place either in Parliament or in a specific body that itself is accountable to Parliament. So this, I think, a bit as an idea of what type of constitutional law arguments are raised against the practice of investment treaty arbitration. I think the same type of arguments can be raised against private-public arbitration on the basis of contracts just as well. And as the German constitutional challenge and also proceedings in other domestic constitutional courts show, this, I think, is an issue that international arbitration, specifically when it comes to such arbitrations involving public bodies, will increasingly face. and I'm relatively sure that similar arguments are being raised, perhaps have already been raised in the context also of legislation on arbitration in Brazil. And if Brazil at some point may move forward to also conclude investment treaties with ISDS, the same type of arguments may come up there. Last slide, of a comparative nature. The exact same type of arguments that we see now pending in the German Constitutional Court are also addressed or have been addressed before the Court of Justice of the European Union. Here also in relation to CETA, the Canada-EU Economic Trade Agreement. And here the exact same arguments were brought to the Court of Justice as violations of EU constitutional law. Non-discrimination, access to independent courts and tribunals, the autonomy of EU law, the supremacy of EU law, the question whether investment treaties leave sufficient policy and regulatory space and live up to the principle of democracy have also been raised before the Court of Justice of the European Union. That proceeding has already ended with a decision that the dispute settlement mechanisms in CETA from an EU constitutional law perspective are in principle fine, unless the dispute settlement mechanism develops too much autonomy and starts restricting European policy space. But if this does not happen, the Court of Justice has actually accepted the EU participating in these type of agreements. What the German Constitutional Court will say is still an open question. My own take is that the decision will probably move along similar lines to the one that the Court of Justice has handed down last year. So my prediction would be that the German Constitutional Court will say that the German Constitution in principle permits investor-state arbitrations, but that the court will also continuously monitor and ensure that investment dispute settlement will not develop in a way that it restricts in the future overly democratic decision-making in Germany. With that, I'm coming to an end, and I'm looking forward to questions and the debate. Thanks a lot.
Okay, thank you very much, Stephan, for your presentation, for your participation here with us. Would you please just stop your presentation, the presentation mode? All right, thank you very much. So we have a few questions here for both of our guests. I will start with a question to Professor Juan Pablo. Professor Juan Pablo, on a legal security point of view, how important is for the parties to adopt, for instance, ICC dispute board rules? If the parties really want to have an enforcement of a decision of the dispute board, how important is to adopt for the rules of ICC or other institution? This is the first question for you. And to Professor Schill, how, depending on the Constitutional Court decision in this case, can we say that it will have a negative impact to the growth of private-public arbitration in Germany, but I mean in a national point of view, so domestic arbitration? Do you think that is going to stop the growth or the evolving of the private-public arbitration in Germany, or is not? There's no relation, such a relation, depending on the Constitutional Court decision in this case. Professor Juan Pablo and Professor Schill.
Well, thank you, Gustavo, for the question. It is, I think it's good to start first with the main concept, which is dispute boards are not an alternative to arbitration. They're certainly not a replacement for it. There are two different procedures that serve different purposes. So for the purposes of legal certainty and for the parties to be able to have the peace of mind that a decision or an issue or a dispute may be finally settled through an appropriate means, it is fundamental that the parties do agree on a formal proceeding to finally settle the disputes, because the dispute board procedure will not be enough in certain cases. And so, of course, agreeing to ICC arbitration is one of the means. We should think, okay, why arbitration and not litigation? There is a very valid question as well. Arbitration has advantages and has disadvantages, and the same goes to litigation. Probably also depending on the jurisdiction where the parties are and the applicable law and the jurisdiction where the dispute may be settled. This will play an important role in deciding whether arbitration or litigation will be the best avenue. In countries where the judiciary is highly trusted, is efficient, is effective, is knowledgeable, and can indeed solve complex disputes, it has the necessary knowledge as well and expertise. Certainly, litigation may be an option. Arbitration on the other side has many advantages. So the inclusion of an arbitration clause within the larger dispute resolution clause in a mid-term or long-term contract is fundamental. So this would be a multi-tier clause, of course, because we just said that dispute boards are in principle, and this is almost universally recognized as a precondition to arbitration as we know it. That means that if the parties do not go through a dispute board procedure first, the admissibility of the claim into arbitration will be questioned, and the tribunal may decline jurisdiction, and rightly so. But it is important, of course, to have a workable system in which you have dispute board proceedings, but for legal certainty purposes, as you rightly say, there must be an effective and workable provision that allows a party to finally settle disputes. The ICC arbitration rules are one of them, but there are many other institutions, regional institutions as well, that may be very appropriate for the final settlement of the dispute. And also, unlike dispute board rules, usually the arbitration rules of the major institutions are largely similar. We cannot say that they are identical, of course, but the patterns repeat. If one knows one arbitration or the set of arbitration rules of one institution, it is very likely that one will be easily familiar with another. Dispute board rules or the sets of rules vary much more, but it is fundamental to have a final form to settle the disputes in the form of, for example, an arbitration clause.
Thank you, Professor Juan Pablo. Professor Schill?
Yeah, Gustavo, thanks a lot for the question. The question was, what impact will a decision of the Constitutional Court on investor-state dispute settlement under this international treaty have on domestic arbitration? The first thing one should know is that domestic arbitration involving public actors in Germany is something that is not very frequent. Mm-hmm. So it's a situation that I think differs starkly from the one in Brazil. In Germany, public bodies use principally the courts to settle disputes under public contracts. There are, however, particularly in important infrastructure projects now, increasing amounts of contracts concluded between companies and the government that actually include arbitration clauses. We've had disputes under such agreements under contracts, for instance, relating to highway toll systems. And we will soon, I think, see another high-profile arbitration also relating to highway tolls in Germany. But these are exceptional occurrences so far. But my prediction would be that, of course, the Constitutional Court decision would have impact on those type of contract-based arbitrations as well, if the Constitutional Court decides that including investor-state arbitration provisions in an international treaty is contrary to the Constitution.
Sure.
This would, I think, raise the stakes for finding contract-based arbitrations to be constitutional very, very high. There are differences, of course, and one needs to distinguish, but I think this would raise the bar high, and likely the government would be the party saying that they cannot agree to contract-based arbitrations. On the other hand, if the German Constitutional Court decides that investor-state dispute settlement under CETA, under this international treaty, is in line with the Constitution, that may, maybe further fuel also the use of arbitration in contracts involving the government. But I think the same type of claims will then also be made towards those arbitrations, namely that one of the constitutional demands of those public-private arbitrations will be transparency. So I think either way, we're probably going to see quite a bit of change to contract-based private-public arbitrations based on this German Constitutional Court decision, independently of which way it goes. Because at the very minimum, I think the court will make clear that transparency is a principle that private-public arbitration needs to respect.
Sure. Thank you, Stephan. Well, we do have some questions from Professor Schiefler and Professor Stephan. Would you please?
Yes, thank you, Professor Justino. Hello, Professor Juan Pablo and Professor Schill. It's we are very pleased to have you here in our classroom. Congratulations for the exposition, for the presentation. I have first a question to Professor Juan Pablo about dispute board. I will make two questions, and please, Professor, you can choose one of them. First, it would be very nice for us to hear from you about the stage of implementation of the dispute board in Europe. In Brazil, we have a very early and premature stage of implementation. We have a few cases only, a few contracts involving public administration that have dispute boards. And we don't have, for example, general rules. We don't have a general law that would tell us what are the rules applying for the Brazilian contract. So we need to look at the international experience to learn how to implement these dispute board projects. So if you have some information about dispute board in European contracts, especially with public administration, like a very short overview, it would be very nice. And second, when we look at the arbitration in comparison to dispute board in Brazil, we see a difference that is very curious. Is that in the arbitration, the composition of the tribunals mostly are the people that are in the arbitration, the members. They come from the law science. I mean, they are lawyers, they are professors in the law schools. And when we look at the dispute board members, the board, they are mostly maybe engineers. And so I would like to hear from you an opinion about the composition of the dispute board. If there is a space for lawyers and professors of law in the board, or if the nature of the institution is more likely to have people from the technical science, like engineering. And maybe if when you have a dispute board with a public contract, I mean a contract involving public administration, if in this case it would be recommended to have someone that is specialized with law issues. So there are two questions. You just please pick one, and thank you very much.
Okay, thank you, Professor Schiefler. Professor Stephan, please.
Well, firstly, I want to express my gratitude for the participation of both of you in our course. Both presentations were wonderful, and I'm very glad that you could participate in it. I actually have two questions to Juan Pablo, and one kind of more complex question to Professor Schill, because I'm still reflecting on your presentation, and I have to elaborate a little more, but I will give it a shot and ask you. Well, firstly, to Juan Pablo, two questions here. In your practice in the Netherlands, how often do you come across a dispute board clause in a multi-tier clause? And also, when you are writing a forum selection clause, what makes you decide to use a dispute board clause instead of a mediation or other method clause? Just 1 second, somebody's calling me, sorry. And for Professor Schill, well, bringing your presentation to our reality here, we have some provisions in our constitution, such as, I will read two of them for you. In Article 5th in Section 35, we have, the law shall not exclude any injury or threat to a right from the consideration of the judiciary power. And on Section 53, no one shall undergo legal proceeding or sentencing save by the competent authority. And bearing in mind that in a few cases, the arbitral tribunal becomes something different from what the parties decided them to do as part of their main mandates, do you see in our reality that investment treaties, arbitration may go the same way they went in Germany? Maybe they are not suitable to be part of the Brazilian order. So in consideration of these two provisions and what you know of our legal system, what's your point of view about this subject?
Okay, thank you, Professor Stephan. We can start with Professor Schill and then Professor Juan Pablo, please.
Yes, so I think the first question that one always needs to ask with respect to the type of constitutional law provisions that you just quoted from the Brazilian constitution and the parallel provisions that we also have in the German constitution. So I think the core question is always what type of situation does the constitution here address? So do they want to prevent the legislator from withdrawing cases by legislation or by other unilateral act from the courts and therefore leave individuals without protection? Or do they, so is that what these type of clauses want to address? And if that is what the clauses want to address, then a waiver of this type of protection through an arbitration agreement, so through consent also of the affected individual, would be completely possible from a constitutional law perspective. If what the Constitution wants to do is protect an individual against unilateral pressure to be moved into a different dispute settlement system away from the domestic courts. This is how I understand the German constitution this is what I understand the German constitution to require. And this is also how many other constitutional courts interpret similar domestic constitutional provisions. So they usually do not want to reserve certain disputes exclusively for the courts if an individual would like to see them elsewhere. But they only require or prevent the state from pushing an individual outside of its domestic courts. I think what those provisions nevertheless require, and I think this is where the thinking then needs to go, is there a constitutional need for some sort of subsidiary protection mechanism of individuals that agree to arbitration against, let's say, arbitrary action that arbitrators may engage in? So does the constitution perhaps require that you have some sort of recourse before a domestic court against an arbitration award? And this is what most domestic arbitration statutes actually provide for. They say, well, if you're not happy with the award, you can go to a domestic court and have it set aside under certain limited conditions. But those limited conditions still ensure a minimum rule of law also for arbitration. I think that's probably where the debate will move also from a constitutional law perspective. I think it's also not smart to interpret the constitution in a rigid way that arbitration would be completely prohibited. It should be allowed, but it should be controlled. And that, I think, is a constitutional law demand one can formulate. But then the debate moves more towards what kind of controls do we need, what kind of controls should courts exercise over arbitration. I hope that answers the question.
It does. Thank you.
Well, thank you for the questions. Very interesting. I promise I'll try not to shy away from any of them. I will also try to be brief, of course. So let me start with the second question from Felipe, which, if I understood correct, was what makes you decide for a dispute board instead of if you're thinking of a multi-tier dispute resolution clause, to go for a dispute board instead of mediation, conciliation, or other forms, like direct negotiation, for example, or amicable settlement provisions. Well, it will mainly and first of all depend on the nature of the contract, the underlying relationship between the parties. As you all know, of course, dispute boards are mainly used in the construction industry, large infrastructure projects, not exclusively in those. There are cases in which dispute boards are also used, for example, in complex M&A transactions that may take a large period of time, where having a dispute board or a permanent body may be useful for the parties. So why would you go to a dispute board instead of mediation, for example? Well, first of all, one should think that they serve different purposes. Perhaps the main issue there is that dispute board, although it can be ad hoc, I think that most of them will be standing bodies that start at the very beginning of the project. They're familiar with the contract, they know the parties, they know the project, they know the performance and the obligations of the parties under the contract. So they serve not only to, and this is very important, and this is something that mediation may have a harder time to accomplish, is that they will help to avoid disputes in a very succinct and fast manner, because they are very familiar with the process, because the dispute board is there before the dispute arises. The mediator, of course, will, in the traditional sense, will only be involved once a dispute has arisen. Once a dispute or a disagreement has arisen, it becomes also more difficult for the parties to agree on a mediator, because you already have perhaps a bit of an adverse relationship. And dispute boards do serve another very important function, which is they help the constructors secure the cash flow. Dispute boards will, in most cases in construction contracts, for example, be able to decide on issues such as additional works and whether the contractor is entitled to compensation for those works, issues of delay, issues of liquidated, possible liquidated damages. So when you need a body that can help the parties swiftly resolve disputes, that is familiar with the issues, a dispute board is certainly the way to go. Mediation could actually be thought of as a next step after the dispute board and between dispute boards and arbitration proceedings, for example. It will be an intermediate step, but it's certainly not a replacement for the labor or for the job that dispute boards do. So you could certainly have a multi-tier clause with 3 steps: dispute board first. If there's a dispute that cannot be settled successfully by the parties using the standing body of the dispute board, then mediation could be a good approach before you go to arbitration. So it is certainly a totally different consideration, a totally different set of factors that parties would think of when let's say when faced with the issue. Do we go for dispute board, or do we go for another type of ADR or dispute resolution method? Perhaps in the context of ad hoc dispute boards, the comparison may be a bit more precise, because of course ad hoc dispute boards will be only established once the dispute has arisen. Then the role of a mediator would be more similar to the role of a dispute board in that case. But in general, I think they come from different perspectives and different purposes that the parties may want to achieve. Now, in how often do I see dispute board clauses, or do we see dispute board clauses in our practice in the Netherlands? To be honest, not that often. The bulk of our work with the arbitration team is not construction disputes. A couple of years ago, we were involved in a large dispute that involved the construction of a biofuel plant in the port of Rotterdam. And in that case, a dispute board was present, but of course we were involved only at the stage of arbitration. So you could see that the parties had agreed upon on a dispute board to be standing throughout the life of the project. But in my personal experience, in the personal experience of our practice, we have not seen it that often. But that's also because most of our work is not focused on arbitration. I'm sorry, on construction disputes. Then Professor Schiefler asked two very interesting questions. I will start with the second one, which related to the composition of dispute boards. And indeed, many times you see, and this is also in arbitration, you see non-lawyers sitting as members of a dispute board, or non-lawyers sitting as arbitrators, although the latter is not that common, perhaps with the exception of highly technical disputes in which engineers may also sit as arbitrators. But it does make sense to have mostly non-lawyers be members of a dispute board. I read somewhere something very interesting, quite funny, that said the procedure through which a dispute board goes in order to try to either avoid a dispute, a disagreement, or to settle a dispute relies a lot on common sense, on a commercial, practical approach, on a commonsensical approach. And the author said that lawyers, unfortunately, or for lawyers, unfortunately, common sense is not always the most common of senses. That lawyers may take or may start with a different approach to the relationship to the dispute, perhaps a more adversarial approach, because, I mean, not always, but because, of course, the training we have received, we will focus perhaps more on the details, on the law than than on the longer commercial relationship. That doesn't mean that we all do that. But it is not uncommon to have dispute boards, especially in complex projects, where of course the legal rights and obligations under contracts will be discussed. To have lawyers serving as a chair or presiding member of the dispute board, that is actually very useful, because then you do have the technical expertise and the legal expertise within a dispute board. Having 3 lawyers will certainly not be the ideal scenario unless you have lawyers that have an ideal combination of expertise with engineering and calculation of cost and delays and a number of areas that are actually even difficult to identify when you want to set up a dispute board from the very beginning. Because of course, in a complex project, disputes or disagreements can arise from a very large number of issues, or from a very large number of contractual provisions or type of performances. So what type of profile you want in your dispute board? It is a difficult question or a challenging question or a challenging step, because at that point, of course, you want to appoint someone to the board that may be able and will be able to deal with all type of disagreements, because no disagreement has arisen yet at that stage. Now, if you also ask what if the public administration is involved, for instance, one of the parties is a public body in the project or in the contract. Well, I think in principle the consideration should not be different. What you may want to have, of course, is a lawyer that has knowledge of public administrative law, of the relevant regulations and obligations, because of course when one contracts with the state or with a state entity, different sets of regulations and a different framework may or will be applicable. But this does not make it in my eyes, is an important consideration. But when one is dealing with a complex infrastructure project between 2 private parties, the legal framework could be also incredibly complex and may very well justify having a lawyer present in the panel. And something interesting under the ICC rules, for example, is that unlike arbitration, the dispute board may render its decision or the conclusion, as it's called under the rules. The steps are the following. Of course, it will make an effort to render a decision in an unanimous way, if not by majority. And if no majority can be formed, actually under the ICC rules, it will be the decision of the presiding member of the dispute board that will be the final word in relation to the disagreement or dispute. So, of course, if one appoints a lawyer as a presiding member, there is a chance that that person will have to decide alone in case of a lack of majority. So you want to make sure that not only the legal expertise is there, but the technical expertise is there as well. And another interesting point is, usually in these dispute board proceedings, which are short, should take no more than 3 months under most applicable rules, there will be a hearing. And in those hearings, parties are actually encouraged to participate without significant involvement of lawyers or attorneys. What the dispute board wants to see is both parties and the representative of those parties trying to commercially, with a commercial mindset, resolve the dispute or disagreement without making the issue a full-blown legal dispute. So it is encouraged that the participation of lawyers at hearings within dispute board procedures is limited, and this is also reflected in the success or the rate of compliance that decisions by dispute boards have. As I mentioned, it's over 85% of decisions by dispute boards that do not go to any further dispute settlement proceeding. So I think that is an interesting observation, and it does make sense that lawyers are not, let's say, that the most welcome members in the dispute board party because of the commercial mindset that should prevail. And lastly, you mentioned also the stage of implementation of dispute boards in Europe. I have to admit, I am certainly not the most qualified person to answer this question. But what I can tell you, for example, is if one looks at the database, and this is only, let's say, as a reference, the database of the Dispute Resolution Board Foundation, this US-based non-for-profit organization that has compiled quite a large database, including different projects in which dispute boards have been used, both dispute review boards or dispute adjudication boards. One will see that out of the 2,800 entries, or out of the 2,800 instances in which a dispute board has been used, I think probably 2,400. So the substantial majority of all these instances relate to a project in the United States. If one looks for instances of projects located in Europe, the number, for what I saw, is perhaps around 50 or 60 from that database out of 2,800. So it's not a significant amount. This does not mean, of course, that dispute boards are not used in practice. The ICC, for example, can we know if the ICC dispute board rules are used often? Unfortunately not. With ICC arbitration, it's much more easy to know because ICC administers the disputes. So that means that the ICC has a very clear overview of how many times the rules are used to resolve a dispute, because the ICC will participate as an administrator of the dispute itself. With ICC dispute board rules, as we saw, the ICC does not administer the dispute at all. So there may be many contracts out there with ICC dispute board rules. You have parties relying on the ICC dispute board rules to avoid unsettled disputes, but this is never communicated to the ICC, also because of confidentiality and provisions surrounding this type of contracts and this type of procedures. The ICC, we know, of course, that the ICC dispute board rules have been used in several occasions, because as we discussed, the ICC provides certain additional services in relation to the rules that it published. For example, the appointment of a member of a dispute board, challenges to the independence or impartiality to the members of a dispute board. So in those cases, of course, the parties will turn and resort to the ICC and ask the ICC to intervene. So the ICC will know unfortunately, the ICC cannot know how many parties have applied on the ICC for rules. And I hope this answers a bit the
Okay. We do have one final question for Professor Schill, and one of our students, Ricardo Medina, has one final question to Professor Juan Pablo. Professor Schill, during over our course here, we read one of your papers, Transnational Legal Approaches to Administrative Law, Conceptualizing Public Contracts in Globalization. And my question is, after so many events, so many changes in the world recently, do you think outside European Union and world organizations, we still have this the public contracts as instruments of global governance in the world today, or it has changed a bit after so many things that we are experiencing in our world today? Do you still have your remarks on this paper from 2014, or you changed a little bit your mind about the function of public contracts related to global governance?
So what I would say is that, of course, in the large scheme of things, you always have a dynamic and a certain cyclical development where, you know, at times the private sector and the instruments that are typical for the organization of markets prevail, and you have times, and these are the times that we've seen for the past 4 years, where suddenly the authorities become more important, the authorities taking unilateral measures, becoming more protectionist, becoming more nationalistic. But I think this is subject to change again. I hope we will see change in this respect, particularly in the United States. And I think we're probably going to move back into a cycle where sort of less nationalism, less protectionism is important, and with that, and also immediately will come back an increasing importance of public contracts. And I think the Brazilian case is really probably emblematic for the developments worldwide. I mean, if you think about your own domestic legal system, how it has transformed also, you know, in relation to global events such as the World Cup, such as the Olympic Games, and with that came suddenly increased investments, increased importance of contracts, increased importance of public contracts. So I think this is a development which probably worldwide still holds, with certain back and forth, but I don't think that I need to revise the position I had on that, you know, published by now some 5, 6, 7 years ago.
Yeah. Okay, thank you very much, Schill. Well, Ricardo, our last question to Professor Juan Pablo, and then we're going to dismiss the class.
Sure. Thank you. You know, first of all, Professor Schill, Professor Pisarro, thank you very much for coming in and giving us your formidable presentation. It's a pleasure for us. We read your text, we read your work, especially throughout all the course. So now, you know, having you guys here is just a huge honor. But you know, I have a question for you, Professor Pisarro. You know, a couple years ago, the RBF held a conference in Japan, and one of the most debated subjects was one that actually provoked a lot of dilemma, and it had to do with the change in the FIDIC provisions for dispute boards. And there, the idea was to, you know, reinforce the idea of avoidance rather than settlement. And for that, FIDIC would even recommend, or at least open some space for dispute board members to meet separately with one of the parties. So my question for you is, how do you see the importance of using mediation tools inside the dispute board in order to, you know, favor avoidance rather than settlement? And wouldn't this sort of procedure raise some sort of conflict, of ethical conflict issues? Thank you.
Thank you, Ricardo. Very, very interesting question indeed. There may certainly be a very serious issue of natural justice in that case, of course. As we saw during the presentation, under the ICC rules, and it is now, of course, the case of the FIDIC rules, emphasis has been put on the avoidance of dispute, and that is certainly a very important role that the dispute boards can play. Some commentators have criticized the approach of the ICC in relation to the 2015 revision to include expressly a whole article empowering the dispute board to actively and proactively intervene to identify potential disagreements, bring it up to the parties so that the parties can solve or reach an agreement in relation to those disagreements without the intervention of the dispute boards. Some commentators have criticized this as perhaps a bit of a paternalistic approach in a way. I do not fully agree with that approach. I think it is a very useful faculty for dispute boards to have. Now, your question is absolutely on point and relevant, because as we saw, the dispute board members individually and the dispute board as a whole may indeed informally participate and engage with the parties separately as well, in order to find a solution to any disagreement or dispute. This means that indeed let's say a dispute board member could have a conversation or a discussion or a meeting with one of the parties in which specific information is made available to this dispute board member, for example. This information may be perhaps may compromise the position of a party if that party would go later on to a full adjudicatory proceeding before the dispute board. And this raises certainly questions of natural justice. The ICC rules, this should not be allowed. Certainly, and there are mechanisms to avoid such problems. Of course, probably, and if one looks at the ICC rules, for example, ICC rules expressly mention that the dispute board may not decide an issue later on, if, for example, if the informal procedure is not successful, and then one of the parties formally refers a disagreement to the dispute board, that the dispute board may not use as a basis of a decision information that has not been available and has not been made available to all the parties involved. So this is a way to prevent the normal interaction in a mediation or mediator capacity to rise up or to constitute a due process issue. Safeguards can be built. I think that the incorporation of express powers in relation to the avoidance of disputes and dispute board rules is important. It does go hand in hand with the purpose of dispute boards and with the role that they are expected to play. But this issue is important. It has been addressed in the ICC rules. I do not know what the status is, to be honest with you, in the FIDIC rules about this specific issue. But dispute board members should be extremely cautious and should tread very, very finely when engaging in formal talks to try to facilitate an agreement. And because, of course, that standing board may be or will be the body that finally settles a dispute within the dispute board proceeding. So whether one of the members may be privy to a certain type of information without the other members knowing this information may clearly affect how this dispute board member may decide if he would have to issue a conclusion, for example. Especially in the case of as we mentioned, especially in the case of the presiding dispute board member, because under the ACC rules, it is possible that the presiding dispute board member, there's no majority formed within the dispute board, may decide just on his own what the conclusion of the process will be. So if this presiding dispute board member has discussed in private with one party, and knows about certain information that the other party doesn't know, or that the other dispute board members do not know, then one faces natural justice issues. So proper safeguards need to be built for such a situation.
All right. This panel was a great opportunity to our Brazilian students to learn a bit more of arbitration and dispute board experiences abroad, to be able to compare them with the practice we have here in Brazil with these ADRs. So we would like to thank again Professor Juan Pablo and Professor Stephan Schill for your time and for your generosity for being here today with us. I am very grateful to Professor Schiefler and Professor Stephan for their collaboration throughout this course at the University of São Paulo. And a special thanks to all our students for their work and their support in all this semester. So thank you all. Stay safe. I hope to see you again very soon. And hope to see Stephan Schill, and hope to see personally Stephan Schill and personally Juan Pablo in Holland very soon. And stay safe, everybody. So thank you very much and have a good day. Thank you.
Gustavo, thanks a lot. It was a pleasure.
Thank you for the invitation.
Thank you. Bye-bye.
Bye, everyone.
Bye-bye.